The second topic on these moral issues is about the law. Principles regarding the law. The law is an ordinance of reason promulgated by a legitimate authority and directed towards the common good. The law can be divided into human and divine. The divine law is divided into eternal, divine wisdom, or natural, participated in the rational creature, and positive, Old and New Testament. The human law is divided into civil and ecclesiastical. The ecclesiastical is the canon law. The first, the divine eternal law. This is the same as God's eternal plan. It is immutable, and all other laws are derived from it. A just human law is derived from the eternal law. When a human law is unjust, it is simply no law at all. Divine natural law. It is the participation of the eternal law in the rational creature. Its object is all that is necessary to preserve the natural order of things as established by the Creator, and which is known by man's natural reason. It admits neither excuses nor exemption, although there may be vincible or invincible ignorance about some of its precepts. Its contents are called the precepts of the natural law. The first and most universal precepts: do good and avoid evil. Do not act against your conscience. Do not do to others what you do not want others to do unto you, etc. Ignorance of these precepts is impossible in any human being. Secondary principles or conclusions that closely follow the first precepts. Here are the precepts contained in the Decalogue. There could be partial inculpable ignorance about them, that is, about one or some in particular, for some time but not for life. As the Catechism states, no one is deemed to be ignorant of the principles of the moral law, which are written in the conscience of every man. This happens especially among uneducated and simple people. Therefore, they might be unaware of the malice of purely internal desires, of conjugal onanism when practiced for medical or financial reasons, of abortion in order to save the mother's life, etc. Remote conclusions. They are deduced through more complex reasoning from the primary and secondary principles. For example, the indissolubility of marriage. It is common that in the uneducated there is long-term invincible ignorance of some of these conclusions. All of these precepts are, however, in themselves immutable, universal, and admit no exceptions. They are universal since they are valid for all men of all races and ages. They are immutable because they remain unchanged throughout the variations of history, and they do not admit exemption since they protect the human person's most basic and fundamental goods. A person can, however, be inculpably ignorant of them in some cases and for some time, and for that reason not be imputed to the person who breaks the precepts. Divine positive law is the Old and New Testaments. Here we are interested in the possibility of an exemption from the divine positive law. Christ, as the author of the law, could authorize the Church to give an exemption from divine positive law. Theologians discuss if he has in fact ever done so. In spite of discrepancies, there is agreement as regards the following principles. The Pope can make explicit and interpret the divine law. The Pope cannot grant any exception from the absolute divine law, that is, those things which Christ established in an irrevocable way, for example, regarding the essence of the sacraments or their number. The Pope can exempt from the divine law that is founded upon some freely performed human act. For example, he can exempt from an unconsummated marriage, vows, promissory oath, etc. Fourth, the human ecclesiastical law. The human ecclesiastical law arises from the Church's legitimate authority for the sanctification of the faithful. Merely ecclesiastical laws, that is, those that do not repeat a precept of the natural law, oblige only the baptized, who are in full use of their faculties, once they are 7 years old, unless the law establishes otherwise. Universal laws oblige all the baptized, for example, to attend Sunday Mass, to receive communion during the Easter season, etc. Territorial laws oblige those who have their domicile or quasi-domicile in that territory and who are present. Domicile is acquired by that residence within the territory of a certain parish or at least of a diocese, which either is joined with the intention of remaining there permanently, unless called away or has been protracted for 5 complete years. Quasi-domicile is acquired by the residence within the territory of a certain parish or at least of a diocese, which either is joined with the intention of remaining there for at least 3 months, unless called away or has in fact been protracted for 3 months. They do not oblige travelers, for example, someone who is just passing through a particular territory where it is compulsory to hear Mass on the patron saint's day. And finally, transients, who have no domicile, for example, the gypsies, who are subject to all the laws that apply in the place where they are. A person is said to be a transient vagus if the person does not have a domicile or quasi-domicile anywhere. The fifth, the civil law. The just civil law obliges in conscience. All true laws oblige before God because it comes from the eternal law. The unjust civil law does not oblige in conscience. For example, when it commands sinful acts opposing the natural, divine, positive, or ecclesiastical law. In these cases, it is rather compulsory to disobey that civil law. And then, when it does not command sinful acts, but it is unjust because it implies an abuse of power, imposes disproportionate burdens, etc. It might oblige in certain cases to avoid greater evils, such as scandal, social disorder, etc. And finally, 6. Causes that dispense from fulfilling the law and interpretation of the law. Above all, invincible and inculpable ignorance of the law dispenses from its fulfillment. Inability to comply with the law also dispenses from fulfilling the law. This inability can be either absolute or physical. The one who has nothing to make restitution with is dispensed from making restitution as long as the impossibility lasts. Or moral inability, that is, with serious difficulty. The act, if carried out, would be heroic. However, moral inability does not dispense when a heroic act is imposed in light of the common good, in case of war or disaster, etc. Dispensation. A dispensation is the dissolution of the obligatory bond of the law performed by the legitimate superior. The one who promulgates the law can also dispense from it. Those who give the dispensation and the one who requests and makes use of it when there is no reasonable cause to do so, however, are not excused from sin. If the subject who grants the dispensation is a subordinate superior who acts by delegation, it is invalid if there is no serious cause. Epikeia. Epikeia is the benign interpretation of the legislator or superior's mind, which the subject himself makes by reasonable judging that the lawmaker's intention when legislating was not to oblige in these extraordinary circumstances, and foreseen at the moment of promulgating the law or giving the precept. The right application of the epikeia supposes that the subject cannot resort to the legitimate superior to obtain the dispensation from him, and that it is an extraordinary case that the superior could not have foreseen. Epikeia applies to all human laws, but not to the divine ones. To exaggerate the seriousness of a situation, to arbitrarily suppose that a superior is away or to wait until he is absent, to omit an observance just because it is more unpleasant than it ordinarily is, are not examples of epikeia, rather but of laxity of conscience. It is a sin against the law or precept to voluntarily and without justifiable cause to place some impediments to its fulfillment, for example, to wait to attend Mass in the afternoon, when the subject will be necessarily busy, when he could hear Mass in the morning.